Hi folks, and welcome back to Innovation and IP. This video is the first video in the video series on commercialization. And if we jump into the Prezi, you'll see that this week's videos on commercialization will deal with the IP due diligence. I like to call it the housekeeping series because it's really what you do before the visitors all come over, isn't it, really? You make sure that the house looks good. And then when the visitors all come over, you may well have yourself an IP deal. Let's have a look at the overview. So in this video series, which will comprise part one of our commercialization series, we will be having a look at the due diligence process and the various bits and bobs involved in it. So identification of the intellectual property itself, listing it all out, identification of any ownership issues, and also validation of the IP itself, making sure that the IP stands up to scrutiny. We will also touch very briefly on management and maintenance of IP. However, given that issue, like the day-to-day management of IP and maintenance issues, proper recordal and registration and ongoing issues associated with management of IP kind of fall outside the purview of this end of the course, because this end of the course is more associated with getting a product and process, an innovation, a creation out to market and commercialising it rather than proper management of it. Although, obviously, you're going to find it much easier to commercialise your IP if you have properly managed it. You'll note that the text this week also discusses various different drivers of IP transactions, and Stoyanov et al. Talk about the various motivations that industry bring to the table when they're talking about an IP deal. They also talk about publicly funded research agencies, or PFRAs, and the drivers that they have. They're kind of hybrid between industry and research. And then they also look at the drivers behind universities and them wanting, institutions wanting to get involved in the whole IP commercialisation process. Obviously, that's a policy imperative now pretty much placed upon the higher education sector. And they are taking it very seriously, certainly after the engagement and impact reporting round, the first round of which happened in 2018, is turning its eyes very squarely on applied research, industrially focused research, rather than the typical blue sky or academic curiosity kind of research. Obviously, that latter kind of research is still very important because it fuels the very, very, very front end of the commercialisation pipeline, but it's certainly not really a focus of interest of the government at this present policy point in time. So that's a brief overview of where we're going to go today, and now we can jump into why you need to do an IP due diligence. Well, I guess it can be summed up pretty quickly, really. A careful attention to detail, a careful checking of all the details in relation to the IP in an IP transaction is the stuff that's going to make the overall deal succeed. And that's what all of the parties want, for sure. Certainly at the beginning of every transaction, that is what every party wants. Both parties are involved and should be involved in the IP due diligence. The aims of the IP due diligence will be different for the investor and the target IP owner. So as far as the investor is concerned, it's all about making sure that you are going to make a sensible investment. And what do I mean by that? You want to ensure that the money you're pumping in is going to be worthwhile in terms of return on investment. So you'll need to obtain an accurate and comprehensive list of all of the relevant IP for the deal in order to expose any shortcomings. Why do you want to do that? so that you can determine the magnitude of the risk that's involved in any shortcomings or problems, and whether or not you can fix them, whether you can work with the IP owner to fix them, whether it's just worth walking away. You want to know about the strength of the IP, and here I'm talking about validity issues. That's the back end of the IP due diligence, where patent attorneys get involved and they assess the strength, the enforceability of the IP. Why do you want to do that? Well, to work out if someone can shoot down your registered IP, have it struck off the register perhaps, or otherwise enter into disputes about the IP and therefore increase the risk of the deal. It will also help to work out what the value of the IP might be. And that is a whole difficult and additional exercise on its own. So that's what the IP investor wants to do. They want to find out whether they're going to be making a good investment. In terms of the IP owner or inventor, pretty much the similar kinds of motivations. As I said right at the very beginning of the video, you want to make sure your house is in order before you invite the guests over. Unfortunately, that's often what doesn't happen out in the marketplace. And it's really only once there is the very real prospect of the visitors landing on your doorstep at any moment that an internal audit of IP is done within a target company. But as I said, the drivers are pretty similar. They want to expose any shortcomings, work out if they can be fixed in order to save the deal. But just generally, it is a very smart, savvy IP owner looking to perhaps get a startup up and running, or a spin-off that goes ahead and does an exercise like this, because it will help to get that fledgling company, or if they're not going to start a company, it will help that get the IP itself investor ready. Okay, you want to make it look all pretty so that when visitors do come knocking on your door, everything's going to look really good and they're not going to be able to help themselves. They're going to want to invest in that IP that you are proposing for the deal. It will also, once you've done an internal audit, it will allow you to get your company's management of IP on track. It's the first step in doing a real rationalisation of the way that the company does business in terms of their IP. So you can get an IP register put in place, you can record the transactions, you can record the details about the IP itself, any licenses, any commercialisation deals that are done, any licenses that the IP relies on in order to function. All of that stuff can be put in place much more easily once the initial audit or due diligence has been done. This, at the end of the day, will help the IP owner to extract the best value out of the IP that's being created in their company. You're not going to be able to commercially exploit, license, assign, all of those good things, your IP, unless you've done an exercise like this. Equally, it might save the company some money, because an exercise like this might reveal that some of the IP actually isn't being used, doesn't need to be used, doesn't align with the business interests any longer, and perhaps if it's registered IP, the company can just let the registration lapse and save itself a bit of money on ongoing registration fees. So that is what an IP owner is looking to get out of an internal IP audit or due diligence exercise. So now, looking at why you go ahead and do it, and bear in mind this exercise can be quite expensive, so it's important to really understand the benefits involved for both parties. What are the steps involved in the IP due diligence? Well, the first one is to identify the IP itself, all of the IP. that might be relevant to the transaction, or if you're doing an internal audit, just identify everything the company has got. So I've said there, it's a bit like Santa, you know, when you're writing a letter to Santa, you've got to make a list and check it twice, as the song goes. That's certainly the case here in terms of checking it twice anyway, with the first step in an IP due diligence. What other things you're going to want to see or look at if you are the IP investor? And I give a more comprehensive list than this in this week's study guide, but just big ticket items, just for our purposes of discussion here, you're certainly going to want a roundup of all of the relevant IP to the transaction. That includes copyright. So it's not just about the industrial property rights, patents and trademarks and you know, confidential information that surround an invention, copyright as well, and any other relevant IP that will be part of the deal. You're going to want to see all the evidence and hard copies of things like the registration documentation, the maintenance of registration, so payment of the registration fees, the ongoing fees. If it's a patented invention or it's going to be patented, you're certainly going to want to know whether or not the company has made any advertent or inadvertent disclosures of the invention out in the public that might cause novelty issues when the invention is sailing through the prosecution process at the patents office. You definitely want to know about anything like that. If you do find things like that, sometimes those things can be remediated. For example, there is as you know, I'm sure, a 7-month grace period for disclosure of an invention prior to the application date. So you might be able to quickly grab and file your application and fix the disclosure that way. Have there been assignments? Have there been licenses? If they have been, then you're certainly going to want to know all about those because they may well impact on what you can do with the IP in the project that's about to be proposed, the project that's on the table. If the person contributing the IP, the owner, has themselves acquired that IP from a third party, you are going to want to see every single document in the chain of title, right from the original inventor through all of the intervening intermediaries down to the current owner. You're going to want to check all of those documents to make sure that every assignment was valid and signed off with someone with the authority to sign. In terms of problems, you're going to want to know if there have been any proceedings commenced for example, striking a patent off the register. That's for novelty problems, lack of invention, prior use, all that kind of thing. If it's a trademark, you might have someone alleging that the mark wasn't actually owned by the owner, and so you're going to want to know if there have been any proceedings filed to remove the mark from the register. If there has been confidential information, you're going to want to know if anyone has emailed the company and challenged the confidential nature of that information. So any problems like that of a litigious aroma, should I say, you will want to know about. Certainly you will want to know about employee ownership issues, and that is the major focus for us today. However, we've hit around about the 15-minute mark, which is probably a good spot to leave this particular first video here, and so I'll jump across to video 2. I'll see you then. Bye for now, guys.